welcome to the firm. On the show this week, what happens now that KFA lenders have invoked Vijay Mallya's personal guarantee? An exclusive interview with the chairman of the ICICI board on the state of securities markets after the global financial crisis. In a rare act of aggression, lenders to Kingfisher Airlines have invoked the personal guarantee offered by promoter Vijay Mallya. Now, I say rare because in this country, bankers have hardly ever taken action against non-performing business promoters, especially one as high-profile as Vijay Mallya. To cut a long story short, Kingfisher Airlines, that has been out of operation since late last year, owes over 17 bank lenders approximately 7,000 crore rupees. Of that, bankers claim they have collateral worth about 6,350 crore rupees, not counting the Kingfisher brand. Last month, after having waited long and hard for Kingfisher to service its loans, banks sold some UB Group shares that had been pledged against those loans. But that yielded them just about 550 crore rupees. This week, CNBC TV18's banking correspondent Gopika Gopakumar reported that banks have now invoked Vijay Mallya's personal guarantee and a corporate guarantee offered by UB Holdings, the group holding company. Now, it seems at the time of offering that personal guarantee, Mallya'S net worth was estimated at 1,500 crore rupees, whereas UB Holdings shares in group companies were worth about 8,300 crore rupees. So, do bankers finally stand a good chance of recovering their money, or rather, depositors' money? To discuss that, I'm joined by Pramod Rao, partner Indus Law and former General Counsel of ICICI Bank, and Jayesh of Juris Corp, both men well versed in matters of non-performing promoters and recovery proceedings. Pramod, Jayesh, welcome to the show. Pramod, let me start with you first. What does it mean to invoke a personal guarantee? I don't think I've seen it in the last 10-15 years that I've reported in this country, and definitely not against a high-profile promoter. What does the process entail? Will it now mean that all of Vijay Mallya's personal assets, have to be sold to pay up these banks?
So, indeed, I would say personal guarantees are demanded by banks from very many corporate houses.
Sure.
So, I'm saying it's not unique to have personal guarantees out there.
No, but it's unique to invoke them.
We've seen corporate guarantees getting invoked. In fact, in one of the structured lending, which was done by, if I'm not mistaken, Morgan Stanley to Unitech Group, they had in fact invoked the Unitech guarantee just about a couple of years back.
Okay.
And which was successfully done in many respects, though they had, and I'll talk about that a bit later.
Okay.
So to me, indeed, I think it's a right step for the banks to have taken. They are, in a way, getting all of what I would call our personal assets, including unpledged shares, which Vijay Mallya probably has or holds through his group investment companies, to actually come on the table as much as the rest of the collateral that the banks have.
Okay.
So I would look at it as a pretty smart strategy to force all that issue on the table.
Jayesh, is this then going to be the Brahmastra that banks hold to be able to get Mallya to cough up? Because we're talking, what, around 6,000 crores, right? They made about 550 crores through the sale of shares. Let's assume fixed assets like helicopters, real estate, the Bombay house, the Goa property, that all amounts to another 500 crores. You've got 1,000 crores of recovery, another 6,000 to go. Is this going to help them bridge that gap?
I don't think so.
Why?
Personal guarantee by itself doesn't mean much. It's what you do against the guarantor which will really make a difference. Now, the odd thing is, unlike a company, if it doesn't pay the debt, you go and wind up. You can't take an individual into insolvency merely because he's not paying his debts. There are other factors which have to kick in before you can actually file.
What more do you need to kick in a situation like this? His airline is out of operation, unfortunately.
No, you have to prove that the individual.
And he hasn't serviced loans forever.
I agree, but this is the absurd thing about India, that the law of insolvency as it applies to a corporate and
does
the law
not apply to an individual.
To the same extent. In the context of when can you take that person into insolvency? So you have to demonstrate that Mr. Mallya has actually deliberately frittered away assets or shifted assets away to avoid paying to the creditors and whatnot, which are pretty stiff conditions to satisfy an Indian court and can take 10 years.
So what is the purpose then of banks doing this?
If I had to step back, I would put it slightly more differently. I would say that insolvency is probably the final step should there be insufficient assets in his own hands to be able to pay off the debt which is because of the guarantee.
Okay.
So I would say we are far away from that. I think clearly what will happen is twofold thing. One is that there are a set of shares which I think Vijay Mallya owns, which
in
are
his
not
own group
pledged
companies
and
or
which are
otherwise
not,
his personal
that's right,
investment.
and which all of which are not pledged. I in fact ran through the disclosures at least on the NSE side, and it appears I would say at least about half, if not a third, is still unpledged.
Okay.
All of that comprise indeed his personal assets, whether held through group companies or directly, which will be available in case of the invocation of guarantee.
But
Right.
you don't,
So
don't
This
just move
includes
against
what
the
he
assets
may
like
have.
that.
Could this include what he may have just sold to Diageo?
It could possibly be.
It could
in
possibly
which case,
do that as well.
In which case, the cash could equally be what is then lying or available for the creditors to sort of look to.
Okay.
So,
No, but you know why I disagree is that okay, you know the personal guarantee, but you need some piece of paper to move against the assets. Indian courts, unfortunately, you know, when you move the court saying that okay, or the DRT here, that okay, I have invoked the guarantee, not paying up, give me a protection order. The time it takes itself to get to a protection order, which is basically the guarantor can't now move away assets, create third-party rights, etc. By the time they would have moved away the assets, they would have created third-party rights.
but all in breach probably of the guarantee.
But what does a breach of contract in India result in? I mean, damages, which is nothing,
Yeah,
and
but
20 years down the line. So, what is the meaning? You use the word Brahmastra, and you know when you talk of that, I think the real Brahmastra is different. Which what I've been tracking is only recently the public sector banks have started using. Some of the private banks and foreign banks have been using, which is willful defaulter. Now, you can't do willful defaulter against Mr. Mallya directly, but you could against Kingfisher on the basis that they enter into significant related party transactions, and it'll be amazing what turns out there. And that constituted siphoning of assets, because the RBI norms for siphoning of funds includes transactions entered in for various considerations. So if I buy something which is worth 100 but I pay 500 for it, that is siphoning of funds.
You're now alleging transactions that
I'm
you
not
don't have
alleging.
any
No,
proof of, right?
No, I'm not even alleging anything like
so
that.
I mean, how do you prove
I'm giving you
willful
the
defaulter
basis.
then?
No, so if
I would
assume
So
for a
if they
minute,
can prove all this, then they can make a case for willful default.
and the consequences are very severe.
Yeah, but that's if they can make a case for all this,
that's
right?
the
That's a
point.
bit of a chance. What do you think?
This is not, Menaka, let's get the record straight.
Huh.
We are not saying that, oh, they have done certain things.
No.
On the contrary, what are the real weapons available which you could explore using? And
But
I think
in these given circumstances, let's assume that no such transaction has taken place because we don't know of it.
Yes.
In which case, can you make the case for a willful default? And if you can't, then is that even an option available on the table? Then you have only a couple of options. You sell the collateral that you can, and you invoke the guarantees that you have, which is the personal guarantee and the corporate guarantee, right?
Right.
Now, to do that, they seem to have sent two notices. One is a SARFACI notice, and apparently they're going to move the DRT in a few days from now. This is, again, source-based information that we have. What is the purpose of two notices? Why do you need this? Which bank or tribunal is going to look at the invocation of a personal guarantee?
Sure. So if I had to just step back, lenders normally take a bunch of securities, right? So lenders like to have as much security as is possible.
Right.
So wherever it is actually assets, physical assets, even aircrafts and so on. So those are hypothecated or mortgaged to the banks. I would assume Kingfisher assets are indeed mortgaged to the set of 17 banks that you mentioned. Those can be subject matter of SARFACI action, which is to say that the physical custody of those assets can be taken and auctioned off without the intervention of the courts.
But that has
Assets which
nothing to
are
do
not
with the
clear.
personal
No,
guarantee,
That has
right?
nothing
Because
to do
that's
with
a
the personal
collateral.
guarantee.
Yeah.
That's the collateral.
What is the role or the connection between invoking a personal guarantee and SARFACI and DRT?
So the way I would put it is twofold. So one is guarantees can be of two types. One is secured guarantees, other is unsecured. More often than not, people take unsecured guarantees.
But in this case, given the history,
Right.
it would be most likely a secured guarantee?
Most likely, I can't speak with knowledge.
Fine,
but
fair enough.
I think
having
the personal
said that,
guarantee is more likely an unsecured guarantee.
And the
because
UB
other
Holdings
CDRs
guarantee
which
is a
we have
secured guarantee.
possibly the
seen.
secured guarantee.
Normally, the promoters do give a personal guarantee, yes, but rarely a secured personal guarantee.
So the SARFACI notice must be for the collateral that they had otherwise.
And
Not connected to the guarantee.
Not connected to the guarantee unless the guarantee is secured guarantee, in which case the assets that are securing the guarantee can be subject matter of SARFACI notice
fine.
also.
All right.
But on the guarantee, personal guarantee by itself, assuming it's unsecured, Mr. Mallya has two choices on getting that notice. One is to actually step forward and say and disgorge himself of what he does have to be able to honor the guarantee. That is one option that he has.
So disgorge means to sell his assets and honor the guarantee.
Exactly. And the other option is indeed for him to contest, to say that, proceed against the balance assets, proceed against other securities that have been posted, look to me last.
Okay.
But usually the guarantee text is such that it allows the lender to say that, it need not exhaust all the
other
available collateral, and they can proceed against the guarantor himself. So the second option Mr. Mallya would have is to probably make an inventory and disclose and reach a settlement to say that here is a schedule over which I will dispose of these assets. To my mind, the way I look at it is the lenders have in a way given a grace to both Mr. Mallya and to UB Holdings by saying that we are invoking guarantee, so you are now going to choose which assets to dispose of to satisfy our guarantee.
Okay.
Should you fail to do that, well, we have the DRT action which will get lined up. While I agree that DRTs do take time in the process.
So the DRT is, if you fail to sell your assets and repay our money, then we use the DRT route to get the court to seize your assets, auction them and return the money to us.
Correct.
Where does personal insolvency come into this?
So only if there is inability and after exhaustion of all the personal assets, there is still an overhang of debt which is unsatisfied. Then is when you can take a person to insolvency. There I quite agree, the insolvency regime is such that it is quite, I would say, cumbersome and onerous in a way.
And also, outside of punishing the borrower, does it go any length in achieving recovery? Because what does the insolvency do?
The threat of insolvency can be quite drastic. Just as willful defaulter has quite significant consequences, shutting you out from the banking credit market.
So the
drop
threat
a schedule,
of insolvency
I'll pay you.
is one axe that you can hang over his head.
Exactly, that's the point.
But the more routine process would be to use SURFACE to be able to get your hands on all the assets that are otherwise with you or pledged with you as collateral.
That's right.
Or part of his personal guarantee if it's a secured one. Use the DRT if he fails in being able to cough up those assets to fructify his personal guarantee, so to speak, right?
Correct. That's right.
And if he fails in doing all of this, then you can maybe pick the route of either willful defaulter or insolvency, whichever suits the moment.
Menaka, my question is, what is the disincentive in India today for a promoter not to pay up? There are all the incentives possible not to pay up because you can use your funds and assets for other ventures. I
don't have answers. I have only questions. Pramod.
No, to my mind, indeed, my sympathies lie with the lenders. To my mind, the minute they have actually parted with funds at the time of disbursement, usually all they have is a piece of paper to back up the fact that they need to get their money back.
So then let me ask the 6,000 crore rupee question. Are they going to get any substantial part of that money back?
To my mind, I would think that given all of the unpledged holdings that I think Mr. Mallya does have, the corporate assets which UB Holdings
whether
does
he
have,
cooperates in cuffing up those assets or not, banks have a fairly good chance of getting their hands on those assets.
That's right. That's my prognosis at least.
As well as the corporate guarantee of UB Holdings. Let's not leave that out.
That's
because
so
if
that's
UB Holdings
value.
is... Yeah,
go file a winding up petition against UB Holdings, and that can threaten the bringing the house of cards down. So
now,
maybe
Jayesh should know, because winding up petitions is his forte. I can tell you that he's used them very effectively against some big-time promoters in the recent past.
That's why, Shyam Benegal's Kalyug, Victor Banerjee is a promoter there who has his guarantee suddenly invoked, and he calls up the bank and says, who's ever heard of person guarantees being invoked? And the answer he gets from the banker is, "Saab kya kare, upar se order hai," or words to that effect. But that even though the movie is 30 years old, isn't that the state of things when it comes to big promoters in India?
Final word then to you, Pramod. Since Jayesh has done his Hindi film dialogue bit, I'll give you the final word on this, which is, where do you see this case go from here? Are we going to look at several years of this kind of legal maneuvering before we see any substantial recovery?
I think clearly to me, there is too much limelight around it for maneuvering to happen in the courtrooms. I think the judges are going to be far more acutely aware of the public interest and the public depositors' money, as you said, which is at stake. So to me, I don't see too much of leeway that the courts will grant. But at the same time, yes, the process does take time.
How long would it take for them to get their hands on Mr. Mallya'S assets, having invoked a personal guarantee?
I would say, knowing the state of affairs where the DRT is today, probably anywhere close to 9 to 18 months.
9 to 18 months?
Yes.
Minimum?
Yes.
All right, gentlemen, we'll leave it there. We'll reconvene in 18 months to take stock of where this case is headed.
Or if a settlement is reached out before that.
Or if a settlement is reached out, or if he's able to revive his airline. I mean, let's hope for that as well.
Right.
Pramod, Jayesh, thank you very much for joining me on this discussion. With that, we'll take a quick break. Coming up on the other side. An exclusive interview with the chairman of the IOSCO board on the state of securities markets after the global financial crisis.